Assalamualaikum warahmatullahi wabarakatuh, and hi everyone, especially to our Madam Nurmedina binti Mahamud. So hoping that all of you are in a good mood and in a good health. So today my group and I will present case on University of Malaya, Wiliaming Chong in 1986. So before that, let me introduce myself and my group member. My name is Nur Shamimi Alia binti Abdul Rashid, and my group member, which are Faizal Mustafa, Azrul Ikhwan, Valentina, and also Umi Shuhada. So in my part, I will present about the summary of this case. In 1964, the University of Malaya, which are the university, appoint Lee Min Chong, which are Lee, to a scholarship offered by the Canadian government under the Colombo Plan, for him to pursue a course of study in Canada for the degree of Master of Business Administration and Accounting. A scholarship agreement was entered into on July 26 in 1964 between Lee and the university. There were also two sureties for Lee. The government provide inter alia that if required by the university, Lee upon his return will serve the university for a period of not less than 5 years from the date of his first appointment, and a breach of this term without the consent of the university will render Lee and his sureties liable to pay the university on demand a sum of 5,000 ringgit Malaysia. After that, on his return, Lee was appointed assistant lecturer in the Faculty of Economic and Administration on June 6 in 1966, and this service contract was to expire on January 1, 1969. In a letter by the university date on July 9 in 1968, Lee was promoted to lecturer and confirmed in his appointment as lecturer in the Department of Economy and Administration with effect from February 1, 1969. Lee declined the offer and gave notice of his intention to terminate his service with the university at the end of his initial contract period on January 1, 1969, in a letter to the university dated October 18 in 1968. Then, the university brought an action in the Session Court against Lee, claiming the sum of 5,000 ringgit Malaysia for his breach of undertaking in the scholarship agreement to serve the university for a period of not less than 5 years. In his statement of defense, Lee contend inter alia that first, the university entered into scholarship agreement as agent on behalf of the Canadian government, and therefore the university itself could not enforce it. Second, the scholarship agreement was void as it was made without consideration. And third, he had completely fulfilled or performed the scholarship agreement, having entered into the service agreement. Its claim was dismissed, and the university appealed. Held, allowing the appeal, first, it is more appropriate that the university should be the principal party in such agreement. Nowhere is it state that the university was acting as agent of the Canadian government. Second, it is clear that there was consideration on the part of the university. This fact that the university appointed him to the scholarship was the consideration on its part for his promise to serve it for 5 years after completing the course, even if there was no consideration on the part of the university. Section 4 of the Contract Amendment Act in 1976 provide that, notwithstanding anything to the contrary content in the Contract Act, no scholarship agreement shall be invalidated on the ground that it lacked consideration. Third, service is not the same thing as post or appointment. Lee gave notice to purportedly terminate his service with the university. This he cannot legally do because there is no provision in the scholarship agreement or in the service agreement for terminating his service.
Assalamualaikum. My name is Umi Syuhada binti Muhammad Afandi. The next section is the party involved in this case. The first party in this case appointed University of Malaya appointed Lee Min Cho to a scholarship offered by the Canadian government under the Colombo Plan to pursue a course of study in Canada for the degree of Master of Business Administration and Accounting. The second party in this case, which is Lee Min Cho as a defendant, were appointed by University of Malaya to study in Canada for degree of Master of Business Administration and Accounting under the Colombo Plan. Lee Min Cho have to serve the university for a period of not less than 5 years, and a breach of this term without the consent of the university will render him liable to pay the university on demand a sum of 5,000.
Now we go to the next section, which is the right and duty for party involved, which is plaintiff and defendant. For my first point is the right and duty for plaintiff. The plaintiff's right, University Malaya, where the sum is specified in the agreement as the amount to be paid in the event of such a violation shall entitle the defendant and certainly shall be jointly and severally liable for payment and the competent authority to be entitled to be paid, notwithstanding anything to the country found in the main act, whether or not the actual loss of harm was caused by the violation, and no deduction from the sum of the name shall be made on account of only any partial duration of service performed by the scholar after completion of his course. Where the scholarship agreement does not specify a monetary sum, the scholar or defendant is equally and severally accountable for payment and is entitled to be payment by the relevant authority. The total amount spent by the appropriate authorities in the accordance with the agreement and the entire additional amount that will cost the appropriate authority or another authority designated by it. Plus, it is to engage a person with qualification and experience like those obtained by the scholar to perform the service required of him upon completion of his course of study for the period specified in the scholarship agreement. Section 5 also addresses the situation in which the scholar violates the agreements and is liable for specific amount. According to Section 5A, if a scholar breaches a scholarship agreement, the scholar is liable for the entire amount specified in the agreement, regardless of whether actual damage was inflicted or the scholar has partially executed his contract. Another set of duties can be found in Section B of the amended Act. The section applied in the scholarship agreement where no amount is indicated as breach. The second point is the right and duty for defendant. The position of the scholar prior and after the passing of the Amendment Act has remained unchanged. This is the right and duty for defendant, which is Lee Min Cho as scholar. The amending acts also do not give the scholar any resource if the scholarship authority violates the scholarship agreement. The liability of the scholarship authority is not addressed because the Amendment Act is silent on the scholarship authority's breaches. As a result, in the event of a breach, the scholar must rely on the Contract Act 1950 and common law to seek redress from the scholarly authority. Section 40 of the Contract Act 1950 allows the scholar to terminate the contracts and treat himself as having been released from them. The scholar must first demonstrate that the scholarly authority has agreed to the scholarship. The failure of the scholarship authority to deny or distribute the entire loan money agreed upon is a clear example of a breach of the scholarship agreements. Another example of breach is when a scholarship authority refuses to enter into a service contract with the scholar after he has completed his study.
For the issue and problem that has been raised, First issue is whether the university entered into the scholarships agreements as an agent of the Canadian government. It is true that the scholarships money was provided by the Canadian government, but it does not necessarily follow that the Canadian government was the principal part in the agreement and that the university took part in it as an agent of the Canadian government. There is no reason why the Canadian government should enter into an agreement requiring the scholarships holder to serve the university. It is more appropriate that the university should be the principal party in such agreement. Nowhere is it stated that the university was acting as an agent of the Canadian government. For the second issue is whether the scholarships agreement was void. University agreed to appoint Lee to the scholarships. If the university had not appointed him to the scholarships, he would not be able to enjoy it. The fact that the university appointed him to the scholarship was the considerations on its part for his promise to serve it for 5 years after completing the course, which he would not be able to take without the appointment by the university. Even if there was no consideration on the part of the university, this cannot be a valid defense in vias of Section 4 of the Contracts Amendment Act 1976, which provide that notwithstanding anything to the contract contained in the Contract Act, no scholarships agreement shall be invalidated on the ground that it lacks considerations. No attempt was made on Lee's behalf to show that the object of the scholarships agreement was against public policy. So, it is not correct to say that it was void either because of lack of considerations or because of its object against public policy. For the third issue is whether Lee has breached his contract. Lee refuses to finish the contract of service with the scholar upon completion. There is a breach going to the root of the contract, and the positions of Lee would be governed by Section 40 of the Contract Act 1950. The principal reason for the grant of a scholarship to Lee is based upon the university expectations that Lee will perform the obligations for the period specified in the contract. Thus, the bargain entered by the parties is that the university will fund Lee educations and in return he will serve the university for the entire period stipulated in the scholarships agreement. Section 5 of the Contracts Amendment Act 1950 states that where a scholarships agreement has been broken by the scholar, if a sum is named in the agreement as the amount to be paid in case of such breach, notwithstanding anything to the contract contained in the Contract Act 1950, the scholar and the surety shall be liable jointly and severally to pay, and the appropriate authority shall be entitled to be paid the whole of such name sum whether or not actual damage or loss has been caused by such breach, and no deduction shall be made from the said name sum on account of any partial period of service performed by the scholar on completion of his course of study. For the fourth issue is whether the university had failed to mitigate its losses. Lee has not shown how the university could mitigate its loss. Even if there was loss which could have been mitigated, the judgment amount can be reduced by such loss in vias of the above provisions of Section 5. The appeal is allowed with cost to the university appellant here in the court below. There should be judgment for the university in the sum of Rm 5,000.
Incapacity, a scholarship agreement or scholarship agreement means any contract or agreement between the authorities in respect of a person such as student regarding any scholarship, gift, assistance, loan, support, or appointment to course of study. The provision of paid or unpaid leave or other facilities, whether granted directly by the relevant authority or by any person or any other body or any government outside Malaysia for the purpose of education or study in any form. The University of Malaya is one of the public universities that has given scholarship to Lee to continue his study in Canada. Scholarship agreement entered into was validated by Section 4 of Contracts Amendment, notwithstanding any possible lack of consideration. The solution for this statement is consideration must be sufficient but need not be adequate simply means providing something is given in return for a promise. It does not matter that it is not much or not what the promise would usually be considered worth. Courts would not inquire into the adequacy of consideration so long as there are some. The reason for this rule is due to the old idea of freedom of contract, which required that the parties themselves should be allowed to make bargains that suit them without interference from courts. The court will not intervene to require equality in the value exchange, as long as both parties have freely entered into the agreement. The federal court determined that there was consideration for buying costs in this case. Even if there is no consideration, the agreement remains valid because Section 4C of the Contracts Amendment Act 1976 states that if there is no consideration, the scholarship agreement will not be void. As a result, Lee Ming Chong must pay 5,000 ringgit measure to University Malaya for violating.